Hi, welcome back to another episode of Law Scholars, again discussing criminal procedure and reoccurring searches. Now we're talking about reoccurring searches of automobiles. Buckle down, automobiles get a little bit hairy, but there are several ways to search automobiles. You have searches incident to arrest. You can search closed container while talking about closed containers in cars. And then I want to summarize the several ways that you can actually get into automobiles to conduct a search. There are four main ways, and I'll save those four main ways at the end because there's a lot of information and a lot of material that we have already covered. So I want to go over all the details first, and then we will end up giving our summary of how to search a car properly. And most of the time, let's just say, it's nearly a free ticket to get into the car, but you have to do it in the right way, at the right time, and if you're an attorney or an officer or the state making the argument that the search is valid, you need to know which arguments to make properly. So, we have here Robinson versus State. This was a search of a car incident to arrest. The rule in Robinson versus State, quoting the case, says, police may search the passenger compartment of a vehicle incident to a recent occupant's arrest only if 1. The arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search, or 2. It is reasonable to believe that the vehicle contains evidence of the crime of arrest. So, two ways there to conduct a search. You can search the occupant's you can conduct a search incident to arrest if the arrestee is unsecured, meaning if they're not in the back of the vehicle yet and not in the back of the police vehicle, they're not handcuffed, and they're within reaching distance of the passenger compartment, which typically is going to be the front glove box, but if there are other passengers, that may extend further as well. Or if it is reasonable to believe that the vehicle contains evidence of the crime of arrest. So it needs to be specifically that evidence of the crime that they are being arrested for. Most of the time, searches incident to arrest are going to fall underneath the second prong, and that's exactly what happened in this case. Because most of the time, people are going to be arrested, put in the back of the police car, and then, what do you know? They're not within reach of the passenger compartment at that point. So your only option is to have a reasonable belief that the evidence of the crime is in the vehicle. So if you don't have that, then you need a warrant or you need an exception. Again, you still need probable cause if you need a warrant and an exception. Exception being consent or where you don't need probable cause for consent, but also an exigent circumstance. But if the person's detained, well, then you're going to have a hard time finding an exigent circumstance. So that's one method of searching cars. This is search incident to arrest. Another method of searching cars is going to be outlined in Carroll versus United States. This is called the Carroll-Chambers exception. Essentially what the rule here says is that there's no need for a warrant if there's probable cause that the vehicle contains evidence of contraband. What's the reasoning for this? Vehicles are movable, and it can create an exigent circumstance that the evidence will be moved or destroyed within a short, reasonable period of time. In other words, the fact that the evidence is within the vehicle makes it an exigent circumstance because of the movability of vehicles. There is another way to search cars. You've got a Terry frisk. This is something we talked about a long time ago at the very beginning. If the officers have a proper basis for stopping the car, if they have reasonable suspicion for the stop, and if they have reasonable suspicion of a weapon, they can check the compartments where a weapon is likely to be found. Okay. One example, one case here is California versus Carney and State versus California versus Carney and State versus Auto. Two different cases, but combine one here because they're very similar fact patterns. But what happened here is that the officers received information about a man in a motorhome exchanging intimate activities for illegal substances. And once the officers arrived to investigate, the man stepped outside of his motorhome, and the officers entered after the person stepped outside, and they found the drugs. Well, a mobile home, is it a car? Is it a home? Well, it's considered a car, so the automobile exception applies if there's probable cause. Here, there was probable cause because they had an informant who corroborated the evidence. The informant had been engaged in this activity with the defendant and tipped off the police, and the police went and corroborated. When the person showed up for those activities with the police, that's where they stepped in and conducted the search. Let's talk about closed containers within vehicles. Well, a closed container is typically going to require a warrant to search. Vehicles, again, underneath the Carroll Chambers rule, do not require a warrant to search a vehicle. So what do you do if you've got a closed container within a vehicle and you're underneath the Carroll Chambers rule? Well, we have a case here that's trying to outline this. This is California versus Acevedo. Here, the rule is that probable cause of contraband in a container within a vehicle is sufficient to search the locations where the container is suspected to be. So you can search for the container if it is in a vehicle. The defense in this case relied on Sanders, which argued that luggage is private and can't be searched, but the response by the state in this case is that it's much more like a car, so the automobile exceptions are going to permit this search. So the question is whether or not the situation is more where it's like luggage, or is it more like a car? Well, what the court says here is that it's more like a car, because the reason for having a Carroll Chambers exception applies, and that is your fear of losing the evidence. You don't want the evidence to just drive away and potentially be destroyed. The dissent in this case does argue that this is more like Sanders to have a closed container. Luggage receives more protection, and so closed containers should receive more protection. The dissent also dislikes the distinction between a stop in the street, which requires a warrant, versus stopping a car, which doesn't require a warrant. And the difference here could be only a few seconds. Stopping in the street, you need probable cause if you're going to do a search. But if you stop a car, you only need a reasonable suspicion to do a search. Well, that doesn't sit right with the dissent in this case. So, what is our summary of automobiles? When and how can you get into a vehicle to search the vehicle as an officer? Well, the general rule is that automobiles are likely to be searched, and any challenges to those are going to be pretty much tossed away. So there are 4 ways to search a car. We talked about all of these. We got inventory. That's Gibson, which we had just talked about just above. Actually, we didn't talk about Gibson, but the Gibson rule was discussed before. We've got Terry, a Terry frisk of a vehicle. We've got automobile exceptions. This is Acevedo, and this is also the Carroll Chambers rule. And then also we have a search incidents to arrest, and this is, again, to illustrate those. So let's work through these one by one. How much can you search? What kind of standards do you need to search? What's the scope of those searches? So inventory searches, as we had just talked about, you need, in our previous episode, you need to have a valid impoundment in the vehicle. The search can't be for a criminal investigation, and you need to have standard procedures. How much of the vehicle can you search? If you have an inventory search, you can search everything as long as the procedure says that you can search everything. So it's just a matter of your scope is going to be the procedure limitations. What about Terry, a Terry frisk? Well, our element here is that you need to have a reasonable suspicion for the stop, and you need to have a reasonable suspicion of a weapon. So in this situation, how much can you search? What's your scope? Well, you can search the passenger compartment for a weapon, and that's it. What are the limits on a Terry frisk search of a vehicle? Well, the purpose is to maintain officer safety, and so you can only search those places where located might be within reach of a passenger. Okay, so that's the second method. What about the automobile exception, which is Acevedo, which we had just talked about? Well, you need to have a cause that the automobile contains evidence of a crime. So you need probable cause, but you don't need the warrant. You just need that probable cause. And the scope of this is going to extend to areas where where there is probable cause that the item is actually located there. So what are the limits here? Well, first you need probable cause, and the scope is going to be limited to the places where you have probable cause. So dual probable cause there. Okay, what about our fourth? Searches incident to arrest. Vehicles here. Well, once there is a lawful arrest, if the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the reach, you can do a search incident to arrest. Or if it is reasonable to believe that the vehicle contains evidence of a crime, of the crime that the individual is being arrested for. What's the scope? You can only search the passenger compartment and any containers that are there. And then also you have the scope of it needs to be within the rules. Okay, so that's everything as far as this material goes. Automobiles, there's a lot. I have a feeling that's going to be tested pretty heavily when it comes to my final, just as a side note. So I'm going to have to go back and review those one more time at the end of this. But for now, that's everything related to vehicles. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.